Okay, guys, welcome to Season 5, Episode 5 of the Quiddity podcast. Today, I'm joined with David Burns, who is a senior litigation solicitor at Ronald Fletcher Baker, which is one of the top 5 lawyer firms in the country. We use them a lot, and today I'm delighted to have David help us through 2 really big topics. 1, renters reform, and 2, leasehold reform. So these are the big kind of major changes that's affecting our industry for the past 40 odd years. So today we're going to be getting to the kind of the nitty bitty grit, because with renters reform, we're 1 month away from it. So David, welcome, thank you for coming over. And so today we're going to ask you really the obvious questions around renters reform, and we'll start there first, because I think this is the biggest change that, quite frankly, it is quite worrying. But I think if people know and understand the context of it, what the changes are, how to protect against it, and also when things don't work out, what are the solutions that you guys can provide. That is hopefully the objective of this podcast. Understood. So tell me, in a nutshell, what do you do at RFB, and how long you've been there, and
Right, so I'm a senior litigation partner at Ronald Fletcher Baker Solicitors. So I deal with all forms of litigation, so property disputes a lot, commercial disputes. I deal with residential landlord and tenant matters, commercial landlord and tenant matters, so commercial lease renewals, defaulting tenants not paying rent or service charge, and as well as normal land disputes, adverse possession, rights of way.
Wow.
Anything with a dispute, people call me.
Okay, great. So hopefully, most people here won't call David, but
exactly,
if you find yourself in, I mean, to be fair, he's been modest. I think David and Ronald Fletcher Baker as a solicitors firm are massive. How many
we've got now, but we just bought a new office in Holborn.
Yes, I've seen that. I've seen that on your LinkedIn.
We'll have to bring you there at some point.
Yeah, we'll have to shoot some videos down there next time.
We are trying to get a podcast studio there. We've got a basement where we're going to try and set one up.
Amazing.
So currently we have 2 offices in London. We're combining them into the Holborn office. We've also got an office in Manchester and Exeter. But we've got about 140 or 150 people. So we're sort of a full service law firm, transactional work and litigation.
And you had a 100-year anniversary.
75, yeah. 75.
Which
100-year will be coming soon enough.
Which I was very kindly invited to in the National History Museum, which was a beautiful evening. So people listening here, so we don't have guests who are, Joe Blogs with one person working in the background. This is serious lawyers, serious solicitors, and giving you the best advice that as property community we need at the moment. So let's get into renters reform. So this is the biggest change for landlords that has probably happened to us since Margaret Thatcher. Really.
Yes.
So what is your understanding of renters reform? How would you summarize it, and what would you say to your listeners right now about what to expect?
Yeah. So it's bringing about a fundamental change in the private rented sector. Okay. So we're first of all going to have no more assured short-hold tenancies, which have been a staple. Most landlords will always have assured short-hold tenancies for their tenants. Yep. Those will disappear as of the 1st of May. Yep. It will be assured periodic tenancies, so they will effectively be indefinite tenancies that just keep rolling unless a tenant gives a 2-month notice to terminate or a landlord terminates using the Section 8 procedure. So it's a massive change.
So there's a lot of things here. So let's just break it down. So right now we have an AST, an assured short-hold tenancy. So for people who don't even know the intrinsic detail of it, so an assured short-hold tenancy is one where you have a fixed end period right now.
Exactly.
So it could be 6 months, it could be 12 months. So that will completely get phased out and it'll be no more. So tell me something about the current existing ones on May 1st. What happens to them? So
on May 1st, they just automatically transfer into an assured periodic tenancy. Whether you do, even if a landlord does nothing, that assured short-hold tenancy will turn into, magically, an assured periodic tenancy, which is just rolling. And it will only end under certain specific circumstances.
So we'll get to that in a minute. So right now, a lot of people are thinking, well, do I need to do something with this tenant that I've got in place here and their tenancy? You're saying...
Yes, you do. Yeah.
So tell me.
That's the thing. Whilst it will automatically change into an APT, there are still some really important things that landlords need to do. So the government has just in the last few days released an information sheet which for existing tenants a landlord is going to need to provide that information, which sets out the various rights that tenants will have, the key information about the tenancy agreement itself, etc.
This is the green document, the one with the green cover that has been distributed.
Yeah.
Okay.
So it's the recent document that the government has just issued, and it must be given to tenants by the 31st of May, or else they risk a £7,000
What
fine.
is it called, the document again?
I think it's a government information sheet, I think. And you can get it on the Gov website. If you just Google government information sheet for tenants, then it will definitely.
And we'll add that onto the show notes as well for people who needs that as well. So, so you've got to give them that by the 31st of May.
By the
2026.
31st of May, yes. And that is in relation to tenants who already have a written AST.
Okay.
For tenants who don't have a written AST, the landlord must provide them with written terms of their tenancy by the 31st of May as well.
Is there lots of people with no tenancies?
Good question. I don't know the amount exactly. There probably is landlords with, a pretty informal approach. Somebody's just came in, they pay the rent, or they've been in there for years maybe.
Gotcha.
So it's that kind of thing.
So these people will need to go onto an APT now.
Exactly. And they will need to have prescribed information served on them.
Okay.
By that date.
So lots of information. So by the 31st of May, we need to have sent an email. Email is fine?
Email or PDF copy. So either hard copy, or they have allowed email by PDF, which is quite good for...
Which is amazing. Okay. So you need to have emailed all your tenants this new checklist that the government has produced by the 31st. Otherwise, you'd said 7,000. What is the 7,000 again?
Up to a £7,000 fine.
That's ridiculous.
So that was one of the things I think investors and property landlords aren't fully appreciating, is the enforcement aspect of this legislation.
Okay.
It's greatly increased.
Okay.
The powers of the local councils to investigate, obtain information, and take enforcement action against landlords for breaches.
Wow.
And it's not only breaches of the Renters Rights Act, it's also breaches of all of the other, the majority of the other previous landlord legislation that imposes obligations on landlords. So it's got far-reaching effects for landlords. So it's going to catch landlords out, no doubt. And already is, because those councils now have a duty to investigate and carry out enforcement against breaches of the they call it the landlord legislation now.
And that computes lots of different legislation
different legislation.
Wow. Okay. So if you don't serve this by the 31st, that's your first almost challenge where you can be faced with a £7,000 worth of fines. And I've also heard that you can go up to £40,000 worth of fine for numerous breaches.
Numerous breaches, or for example, if you're attempting to evict your tenant without using the proper processes set out in the Renters Rights Act, then that will amount to quite a serious breach, and it could lead to a penalty of up to £40,000.
Okay.
If you are breaching all of the HMO legislation that is out there, for example, then that's another opportunity for substantial fines against them. If you're serving, for example, a Section 21 notice on a tenant after the 1st of May,
which is not allowed,
you can expect another fine.
Wow. Yes. Okay. So there's a lot of changes. So just to sum it up, the Renters Rights Act is going to basically almost bring the enforcement of all the existing legislation in a much more of a higher priority. And that then will get enforced by the local authority. And guess what? They're looking for money, right?
Well, good point. Not only are they looking for money, it's been set out that the money that they generate via these fines...
Please don't tell me they get to stay.
They get to keep that. So it's like a self-funding regime.
Wow.
And also, importantly, it's important for a lot of landlords to consider as well that in addition to the council's ability to enforce and fine landlords, there is also the ability for tenants to now obtain rent repayment orders, which are double the amount that they were before. So currently you would have a rent repayment order up to 1 year, where they're changing that to allow the tribunal to impose 2 years worth of an order against a a landlord, and that can be applied for offences now which date back 2 years. It was previously 1 year.
Wow.
So you could have a situation where if you commit some breaches, for example, of HMO legislation or failing to get selective licensing, etc., which Rachel Reeves herself failed to do, then you could not only get penalised from the council, you could face a substantial rent repayment order.
Wow.
So compliance is going to be absolutely crucial going forward.
So, okay, so just wrap this up then. So nowadays, landlords in 1st of May will have the Renters' Rights Act to comply with, which means there will be no Section 21. They will not be allowed to have an AST, so a short-haul tenancy. It's going to be a periodic tenancy. That means that the tenant walking in today can stay for as long as they want, but they have the right to give 2 months' notice and leave whenever they want.
Yes.
Conversely, though, the landlord cannot serve any notice unless there are 4 main criteria that are met. Can you tell us what those kind of main criteria that the landlord can serve?
Well, there's several grounds. So there's a lot of mandatory and discretionary grounds. So there are more than 4, but some of the widely spoken about grounds are, for example, if a landlord wants to sell the property.
Yep.
But even in that circumstance, a landlord still will need to give 4 months' notice.
After the first year?
Well, 4 months' notice, and it must not expire. It must expire later than the first year. So you could probably serve on month 8.
Okay, and then
given 4 months' notice, so it expires after the tenancy has been in existence for at least 1 year.
Yeah.
But then with that ground, and similarly with the ground for wanting to move back into the premises yourself with your own family or immediate family, then if you serve that notice, then there's a restricted period on reletting the property for 12 months.
Which is so punitive.
So punitive. And it seems harsh that in circumstances where, for example, the landlord genuinely intends to sell the property, serves that notice on the tenant vacates. If for any reason, the sale falls through.
And what's the average? I think I read somewhere, 30% of all sales fall through. So you just put that as a number for a genuine landlord exiting.
Yes.
Landlord has got a property that he now cannot re-rent to the next tenant for 12 months.
And if the person that you're selling your property to knows that you have served that notice and can't relet for 12 months.
Oh, wow. They've got leverage.
They've got, don't they? Like you would, of course you would. Because if you say, well, actually, I want to chip the price down by 25%.
That's crazy.
Then what are you going to do? I suppose you could not accept that and start the conveyancing process, try and find a new buyer.
Purchaser.
Yeah, new purchaser.
So also the other way, I didn't even think about the seller trying to leverage, the buyer trying to leverage. The other way is you potentially have thousands of properties in the future that cannot be relet because they've triggered genuinely to try and get out, that they now can't sell, and now you've got a housing crisis made up. Perverse incentives, right? It's completely unintended consequences of this legislation.
I would have thought that they would have had a caveat in to say, well, if a landlord served that notice with a genuine intention to sell, and if, for example, the buyer dies or pulls out for no fault on the basis of the seller whatsoever, and they can demonstrate that, they should be allowed to relet. But that's not. There's no such caveat as far as I can see.
That is crazy. Okay, so now you've got two reasons. Well, you want to sell, you want to move into with your family.
Yes.
What are the main reasons for you to get your property back?
Well, another obvious one is rent arrears. So, for example, if the tenant, but they've changed that ground as well. So you now need to give at least 4 weeks' notice. It was previously 2. And
so that's the tenant has now in breach and not paying for 2 months.
So that's what it currently is.
Yeah.
Now it will, after the 1st of May, it will be 3 months.
So the landlord has to absorb 3 months of mispayments.
Yes.
And then serve the notice after the 12th week.
Yes.
And then they've got another, how long before?
Yeah, that's a good question then. After that, you have to issue a claim in court.
Yes.
You then have to serve it on the defendant, the tenant, to see whether they want to defend that claim. And then it gets listed for a trial or a hearing at some point.
Yeah.
How long is all that going to take when you've now got no more Section 21s that usually speed through reasonably quickly?
Yeah. That could be, on average, I can tell you, we're going through a few of them at the moment. 6 months to 9 months is your average right now. And that's right now, before this huge You can imagine that there's going to be a section of the tenants who say, hang on a minute, I think I can not pay for 3 months.
Well, exactly.
And see what happens, because it's...
Yeah,
why
or
not?
what a tenant could do if they want to be clever as well is they could stay at, say, 2 months and 2 weeks
I was going to
rent
ask you
arrears.
this. Yes. So this is another perverse incentive for tenants here. So just if listeners are thinking, well, what are we talking about here? So right now, a tenant, if they are in arrears for 2 months, you have to wait for the 2 full months before you can trigger a possession order from the court. In the future, what you're saying is that's going to have to be 3 months.
Yes.
To trigger a possession order in the court. But if they stay within 2.5 months, always, you can't trigger that possession order.
Well, what you can do is, so there's 2 types of possession grounds. There's mandatory grounds, and the 3 months rent arrears falls within a mandatory ground for possession. There are also discretionary grounds.
Okay.
And one of those discretionary grounds is persistent rent arrears.
Okay.
So if a tenant was trying to play the game and keeping it at 2.5 months rent arrears, then a landlord could make a decision and say, well, actually, I'm going to still bring a possession claim on the discretionary ground.
Yeah.
But the obvious risk there is you could pay a lawyer like me, go all the way to a court, right before the hearing the tenant could pay the rent. And because it's not a mandatory ground, the judge could turn around after you spent all that money on legal fees and say, actually, I'm going to give him a chance here, but, give him a slap on the wrist. Don't give a possession order, and the landlord...
Assuming that they pay the whole 2.5 or 3 months in arrears, not just the 2 weeks that they were they keep kind of putting down.
Now, you would hope that a judge, if it was a cynical attempt, then they would see through it and give a possession order, but there's no guarantee for a landlord.
I mean, I'm gobsmacked. I mean, I know these regulations are coming in, but I'm still, every time I hear it, I'm like, this is ridiculous.
Well, and do you know what? For most lawyers, say, for example, if you came to me with that problem, we would be quite reluctant to press ahead with a claim for possession on a discretionary ground, because we know we could do everything right, prove our case entirely, but we might not get you possession at the end of it.
So then you would go for the mandatory grant, which has to be 3 months. So if somebody is not playing this silly bugger game of 2.5 months payment, what do? We just accept it?
You'd have to make a judgment call on if, I would probably say if they were doing this month after month and it's quite plain that's what a tenant is doing, I think you may say, all right, enough is enough, I'm going to go.
What is a reasonable time? Is it 3 months, 6 months, 9 months? Yeah, because the judge could be...
Yeah, good question. And also it can depend on the judge on the day. It could depend whether it's a Wednesday or a Friday and the judge is in a good mood or a bad mood.
I mean, that's just ridiculous. How do you run a business with having kind of no real set rules? Is just, well, I feel like this today, I don't feel like that tomorrow.
That's
mad.
It's going to be a decision for landlords to.
Okay, so let's keep rolling with the bad news. So Section 21 is over. You have got periodic; they can stay forever or leave within 2 months of serving you a notice as a landlord. You can't serve them a notice to leave unless you got those 2 criteria that you want to move in or you want to sell it. Any other they haven't paid Section 8 notices. Any other thing that they?
Yeah, so you've still got the existing like antisocial behaviour.
Okay. So how do you prove antisocial behavior is going to be a nightmare? What, just start to film people for making...
Well, you're probably going to want, I think under the new legislation in particular, you're going to want evidence from neighbours, for example, or people who've been the victims of that antisocial behaviour, whether it be noise or aggressive,
police
behaviour.
reports. Okay.
The more corroborating evidence you can get, I think the better.
Can we agree this is going to be the hardest one to probably...
Yeah, again, it's one where because you're relying on witness evidence of other people, then it probably depends on the severity of the antisocial behaviour as well. Because if it's one night playing the drums, if it's somebody that you suspect is selling drugs from the premises and they're having being very aggressive to neighbours or even hitting neighbours, etc. You're probably and sometimes that would be tied in with breaches of the lease in general, so that would be another ground. If tenants are just persistently breaching the terms of the lease, then or the tenancy agreement, then that's another one.
Okay, so here's another one. So what about pets?
So under the legislation now, you're going to have to reasonably consider any requests for pets.
Okay.
So you can't just...
So you can't say, you've got pets, we can't give you... Yeah. And also there's another one around people on universal credit, right? So you can't And I think that's right, to not discriminate.
You can't discriminate in your advertisements for letting, and also you will have to give a fixed price for your rent.
Okay.
So because you're not allowed to
Have a bidding process kind of thing where people used to kind of bid out and then push the prices up. Okay.
Another thing which I have a slight issue with as well is that one option available to tenants now is you could advertise your flat for sale.
Yeah.
A tenant could agree that rent, move in, get the keys, sit down on the couch, and that very next day apply to the tribunal for a determination that the rent is above market value and ask for that rent to be reduced.
Okay. So how can they do that if it's market rate and they've been advertising it as a market rate?
And they agreed to it. So
Yes.
if the tenant literally agreed to that rent, accepted the tenancy, but they've got the opportunity to then apply the very next day for up to 6 months from the start of the tenancy, they can apply for a determination from the tribunal.
But does that mean they still pay the rent for now? Or
They still have to pay the rent.
Okay, but then they have a...
But and you think it's a bit like going and buying a car.
Yeah.
You go buy a Bentley.
Yeah.
Drive it out and say, well, actually, no, I don't think the price was right. I want to keep the car, but I want to have a lesser price.
That is incredible. Okay, so we've got a huge challenge coming up our way, and what is the safeguards that you would, if you had to kind of say to landlords right now, you got a month or two, what should you be doing right now that you can feasibly do to help yourself in the future?
Important steps for landlords to take. Number one, familiarise yourself with the legislation, whether that's by reading the government website or other experts, online to get an idea of what they need to comply with.
And people can read on our website as well. We're going to start to put a lot of that information in on our website to help landlords comply, basically, to be compliant with it. Okay, so read the legislation. What would you next ones?
Number two, get your paperwork ready. So, for example, those information sheets, understand what information needs to be given and when. Maybe sign up for, there are notifications you can get from the government websites if you want to sign up for those. So
that's quite helpful, that the .gov.uk property stuff, they can then send you any updated notification that you need to send. Fine. Okay, that's good advice.
Get your advertisements, etc., all in order so that you ensure they're compliant.
Yeah.
Also, what other, I would say, I think those are the first three I would say that are important.
That they can do right now to prepare for.
Ensure your rent review mechanisms are as per the terms of the legislation, which will be now 12 monthly. So every rent review can only be carried out once per 12 months.
Okay.
You need to give 2 months notice of any rent review, and it must be in a Section 13 notice.
So you have to serve that notice in the right manner, not just write to them and say, we are thinking of getting your rent up. If you don't do that, you're going to be in serious trouble.
Exactly.
Okay. Yeah. Right. Okay. So clearly there's a lot of changes. We've got a few minutes just to kind of do a quick fire around renters reform for you, David. So Section 21, fully gone?
Will be from the 1st of May.
Okay. Section 8, becoming the main route for landlords to use?
Yes.
Evictions, is it going to be slower or just more structured in the future?
Slower, I would say.
Yeah, because there's going to be many more cases, not enough judges, not enough courts to proceed.
And more room for dispute, about some of these things. Whereas previously with the 21, it was either valid or it wasn't. You get possession or you don't. Now, if we're talking about antisocial behaviour, rent arrears, these things have scope for dispute.
I think you've spoken about this already. Rent increases more restricted?
More restricted.
Because you're only going to do once a year in a structured way using the right notices.
Yes.
Tenant power, would you say, is significantly higher now?
Tenant power significantly higher. Council power significantly higher.
That's the scary bit. I'm not even bothered about the tenant bit. The council looking for money, they're going to go out and actually look for these.
Some of those councils are broke.
Yeah, so most of them are broke. Yeah.
Most of them are broke. And if you think as well, if you get a landlord with, say, a portfolio of 100 properties, and you identify a couple of breaches on one, then that officer in the council must think, wait a second, I could 100x my money here.
Yes, yeah. Hopefully, if it's not in the same council, you're right. But if you bought everything in the same council area, you're going to be seeing some serious challenges. Do you see, and are you seeing a lot of your clients getting out of property market in the last few months?
We have seen an increase in Section 21s being served, and we have seen some landlords exiting. Yeah.
Biggest compliance change that you say that is coming, what would that be from a landlord perspective?
So the enforcement of all of the landlord legislation under this Renters' Rights Act. So compliance is now absolutely paramount.
Wow. And that's the scary, because it's not just the renters' rights, it's everything.
It's everything.
That they're going to comply.
Yeah.
And my last question is, what mistake landlords will make, you think, in 2026?
Breaching the landlord legislation, either by serving Section 21s, not giving the prescribed information. There's so many ways to breach that legislation now that I think there's a reasonable prospect. A lot who don't have professional systems in place. So probably, as a simple answer, would be not being as professional as is needed.
And I think you've just given me an idea here, which I think you will probably agree to, is we need to stop. We might ask you to sort of help us run some webinars to teach people how to do this better, because to get them prepped up, we've got 4 weeks, 6 weeks to go. And I think we know, there's a lot of gap in people's knowledge that we will need to breach. So,
well, the other thing on that as well, even the Act itself, if anyone tries to read it, it's really difficult to read.
Right. Even as a lawyer, you say that. As
a lawyer, because what they've done is, it's not, because the Renters' Rights Act builds upon all of these other pieces of legislation going back to 1988, and so it's not just one self-contained piece. It refers, in several schedules to amend in an earlier piece of legislation. So not that many people are going to stop pulling up multi-screen versions of different pieces of legislation, which is why I think using the government websites or your website or other people's websites is so important.
And I think, as a wrap-up from an investor who, we've got hundreds of properties, we are also saying to people listening to this, if you've got 2, 3, 4, 5, whatever the number is, really get your prepped up in terms of the compliance. But also, we are now also using managing agents, good managing agents locally, who understand the compliance issue, the legal issues, and actually what will happen with the management sector. I think the guy with a piece of paper that writing tenancy, that's gone now. That's not going to survive, and we're moving. So as if you're listening to this and you're thinking, what can I do tomorrow? Start to look at who's managing your tenants, who's managing the property, and get that right. Otherwise, you will be in hot waters.
Yes, I think an important point is to ask your letting agents, what are they doing to prepare for the Renters' Rights Act, and are they able to assure you that they're going to be able to keep compliance high?
Yeah. So just to wrap up then, so if we have a problem, landlords have a problem, people have a problem, who do they come to and how do they get in touch with you?
Yep. So I'm David Burns, and I'm on LinkedIn, and also it's d.burns@rfblegal.co.uk.
We'll put that on the show notes as well. And realistically, a lot of people will just drop you an email to say, here's a situation, can you help? And then book a call with you or something.
Yeah. And it's actually a growing part of my team's work now is residential landlord and tenant.
Yeah, I can imagine for the next 5 years you're sorted that. You're sorted for the next 5 years.
Good news for lawyers.
Yes, good news for lawyers and counsel. That's the summary of it,
What was the silver lining?
Exactly. But listen, David, thank you so much for taking the time to come in and see us, talk to us, scare us. You did that in November as well, so thank you for that. But again, it's about just understanding what the challenges are, making a headway, preparing for it, and knowing where to go when things don't work out. So thank you so much. And hopefully we'll see you on one of our webinars when we'll run that certainly over the next few weeks or so.
Good man. Thank you very much.
Thanks a lot.